Good evening. Welcome to week 9, the construction of a contract. And as in the past, what I'm going to do is I'm just going to go through the subject matter first, and then we'll do our question at the end. Any questions before we start? So we've got Jason, Mary, and Michael so far. That's good. Okay. Look, when you go through the materials, there are 3 main headings there. It's the clarity of the words in a contract. And then we're talking about the exclusion terms. And then we're talking about some key clauses like entire agreement, or also known as entire contract, termination, force majeure, and things like that. We'll cover all that today. You know? So, the last 2 days I've been running seminars for business people, and I'm actually worn out standing all day from 9 to 5. So can someone give me what they think a summary of the construction of a contract? Let's say it's plain and easy to understand. What's the golden rule there?
If the words are easy to understand, then the contract must be read that way, regardless of the outcome.
Good stuff. And what happens if there is some ambiguity?
Depends if there's 2 interpretations. The courts will favour the one that seems most reasonable from an objective point of view.
What about if it's a minor ambiguity? And the courts will apply
the surrounding circuit.
Yeah, the courts will apply an interpretation which makes the most commercial sense, and that's what a reasonable person would have looked. And that's in your notes. Just point you towards it on page 6 there. But what happens if it's a more substantial ambiguity? Well, the courts will do a look at the facts, the factual matrix, and see what's going on. And I've got here, you know, the court will look to the surrounding factual circumstances, also called the factual matrix, to place the hypothetical reasonable person as closely as possible to the circumstances which were encountered by the parties when they made their contract. And that's the Pacific Carriers and BNP Paribas case. Okay, then we had quite a famous case called the Cadelpha and State Railway Authority of New South Wales. We'll come across that a number of times in your law degree. What happened there is that the government wanted to build a railway line from Central, or from the city of Sydney, out to Bondi Junction. And it wanted to do it quickly, and it had a contractor, and it was agreed to make him 24 hours. There was lots of demonstrations, and I know all that because I was one of them at the time, a long time ago. And so it's all blown up, but this part here was one of the judges, and I think it was Mason who said basically they made it quite clear. If the words are clear, you can't use the surrounding circumstances, and you can't use surrounding circumstances to argue the words in the contract are ambiguous. You know, so basically, if it's clear, got to stick with it. If there's an ambiguity, well, then you look a little bit further into it. And as we said before, the court doesn't like to have a situation where it's left unfair. So even if the result is, even if the words are a little bit strange, they'll want to have something which is not fair. Now, I'd like to talk about exclusion terms. Can someone tell me what an exclusion term is, or exclusion clause?
It's where something's been excluded, where you're leaving out something. So you might be leaving out liability.
Yeah, look, it happens all the time in contracts. basically, I'll write a contract and I'll write, I will do this, but I will not do that. That's an exclusion. And when a person signs, can anyone remember the case, the key case in signed contracts? That was with the vending machine.
With which what? Sorry.
What was the key? When a person signs a contract, they're bound by it. And
Yes.
there's a case we normally quote with that. Can anyone remember that case? It dealt with a vending machine.
Oh, Lestrange.
Lestrange and Graucop. So commit that to memory. And I mean, obviously you can't remember thousands and thousands of cases, but there are a handful of good ones. And wherever you go, Lestrange and Graucop is a really important one. And it's a little bit unfortunate. Nowadays, would the result be different nowadays? Now let's go for the facts. Does anyone know the facts of?
Well, she bought a vending machine, didn't read the terms and conditions. Then the machine failed. So then she tried to source remedy. Then she found out the exclusion clause. But the ACL consumer law would remedy that nowadays.
And how would I agree with you? How would they do that?
In fact, of warranties.
Yeah, because you can't. There are certain exclusion clauses which will not be allowed to be effective.
Yes.
And that's one of them. Good stuff. So with the signed document, really, once you sign the document, you're pretty well bound by them. But let's have a chat about unsigned documents. There was a case of Ollie in Marlborough Court. Anyone remember that case? Okay, so Mrs. Ollie was wealthy, and this is just post World War II in London. And she went to Marlborough Court Limited, which is a hotel, and she was wearing a big fur coat. She was quite wealthy, and she went downstairs, checked in, went upstairs. On the back of the door there was a sign. I don't have the words on me at the moment, but it's something to the effect that the hotel would not be responsible for any theft or loss of the possessions of the person staying here unless they've been checked in. Okay. So now let's have a look at it. She decided to go for a walk. She realised it was a warm day outside, and so she went out the room, locked the door, went for a walk, came back. The door was open, and the coat was gone. She went downstairs, wanted compensation for it. What did they say to her? Sorry, exclusion clause. Okay. She went to court. Who won the case?
She did.
She did. So why did she win the case?
Because the signs on the door were after the contract formation, which had been done downstairs when she signed in.
Exactly. And in day-to-day life, you'll see this happening quite a lot. A tradesperson will enter into a deal with you, then later on they want twice the price because they've done twice the amount of work, or whatever. You've got to be firm. The contract says X, and that's it. Now, the interesting thing is, and we haven't studied it now, but in due course we will one day, is we have this doctrine of notice. And as we said before, and sorry, there's a bit of feedback there somewhere. There's a doctrine of notice. And if she was aware of that clause prior to going into it, there's a good chance it could become a term of the contract. Now, but she wasn't aware of it. But what happens if, let's say, who's there? Michael or Mary or Jason, one of the three of you, you're the barrister for the hotel, and you said, this is Ollie. You're wealthy, aren't you? Oh, yes. And Mrs. Ollie, you travel a lot? Yes. And Mrs. Ollie, can you please tell the court approximately how many days you've spent in a similar hotel with a similar note on the back of the door? Or, Your Honour, I would say about 50 in the last year. You see what I'm getting at? It's called notice, constructive notice, in the sense that she should have been aware of it. Okay? So therefore, she can't say that she wasn't aware of a term on the back of the door. Now, was it not last week we did Balmain, New Ferry and Robertson?
Yeah.
And in that case, Mr. Robertson should have known about the terms and conditions on the sign above the turnstile for a number of reasons. He was a barrister, in other words, he's a lawyer, so he sort of knows those sort of things. He's been going in there backwards and forwards a long time, every day. And it really wasn't that difficult to see. It was only just above the turnstile, you know. It's not as easy as it looks in the sense, oh, well, you know, it was on the back of the door and contracts made done. I'm agreeing with you, but I'm just sort of making a point. That's what I'm trying to say. Just keep in mind that if the person had done this a lot of times, although they may not have seen it then, it would have been, the notice maybe could have been there. So I just wanted to point that one out. That's Ollie and Marlborough Court. Now, in the materials, we spoke about misrepresentation. What is misrepresentation anyway?
Saying it's one thing when it's really another.
Yeah, that's a good point. If you look more deeply, we have a number of different types of misrepresentation. We have innocent, fraudulent, and negligent. And that's not relevant now. But it became such a hassle under contract law in order to get a remedy for this, really was a headache. And sensibly, what the government did, it used its legislative powers. This is the Commonwealth government, which has been repeated through the states, Queensland, New South Wales, Victoria, etc., in the Fair Trading Act. And basically, we have this misleading, deceptive conduct part, and that's sort of superseded. That's not to say you can't still use misrepresentation. Okay. Which one of you would like to have a go and tell me about the Curtis and Chemical Cleaning Company case? We alluded to that last week.
That's the wedding dress one.
Yeah. And so guy went in, took the wedding dress in and said he wanted it cleaned, or the person took it in. And the response from the person behind the desk was what?
Take the money, then state the exclusions of that if it's stained, it's not their fault, but it's post-contract.
Yeah. So it's my recollection of the case that the person who took the dress in handed it over and was surprised to get a document that the person had to sign. When asked about what were the contents of this, the response was, it's to protect us. We have an exclusion clause in relation to the beads and sequins. And the person who was putting the goods in for laundry, I said, oh, that's okay, fair enough. And went ahead. Came back, there was a huge black stain on the dress, and said, what's going on here? I want compensation. And the response was, no, have a look at this agreement that you signed. Okay? We're excluded from liability. So who won that case?
Curtis did.
Yep. And why did he win the case?
Because the exclusion clause was after the contract.
I think you're thinking of
misrepresentation, wasn't it? Because they said that it was only going to, she was signing a contract to say that the beads we wasn't liable for the beads being damaged, but not for the stain. They didn't specify that.
Yeah. I think, Michael, you're thinking of Ollie and Marlborough Court. This one here is that the person at the desk gave a genuine answer thinking that they were correct, but it was wrong. Irrespective of that, it's still a misrepresentation. So based on that misrepresentation, Curtis went into the contract to his detriment. And what the court said, I'll just read out my little notes here. The exclusion clause will have no effect if obtained by misrepresentation, even if the misrepresentation was an honest mistake. Okay? And under the heading of notice, there was a Victorian case Now, I may have mentioned it last week. Is someone goes in? I really can't remember what for shirt or something like that, and they were given a ticket, and they just put it in the top pocket, you know, which is what we normally do with these things, and went back, and there was it was lost or substantial damage or whatever. Wanted to claim, and they said, "Well, look, man, have a look at the back of your ticket. You've got all this." All these exclusion clauses, and we don't have to compensate you for this because we're excluded. And he said, "Well, I didn't know about it," and that's the whole doctrine of notice. Because in the English legal system, which we've inherited, it's not just to have someone responsible or missing out if they weren't advised. Okay, so this notice is actually very important. So said another way, if you want to bind someone, be very careful with notice. Now, I can't remember. Why I keep on saying this is I had 2 days of full-on contracts with executives, so I just can't remember what I said. But I remember doing this case a couple of days ago, and maybe with you last week. My wife, my friend got married, and my wife and I went to the church and went to the hotel afterwards here in Melbourne. And I couldn't find a parking spot, and we were late. And I just said to my wife, "Look, we'll just get the valet to take the car." And I gave him the keys, and he gave me a piece of paper slightly bigger than this. And on the top of it, it had the name of the hotel, and had 3 or 4 or 5 terms and conditions. And I had to sign on the bottom. Now, you yourself said before Lestrange and Graucob. What's the legal effect of Lestrange and Graucob?
If you don't read, you're still liable.
Perfect. Right. So whatever the terms and conditions are, irrespective of whether I've read them or not, I'm bound by them. And this is irrespective of whether it's a little thing like that to do with a car or a big oil tanker. It's the same thing. And I may have given you last week I think I did, about Crazy John. He lost $43 million on a signature. And he said, "Oh, but I didn't read it." No, well, you know about that. And there was an entire agreement clause, which we'll talk about later on. So I went, I signed that document, and let's say the man, on the document, they're exempted from damage and stuff like that. Okay, so when he takes my car and he goes downstairs, he bumps it, causing $1,000 damage. Who needs to pay for that? Does the hotel?
You do.
Yeah, probably most likely I would, because the hotel would rely on that clause. Now let's assume situation B now. The guy who took the car from me, if you look at his nameplate, his name was Ferris Bueller. Okay, and you've probably all seen the film, The Ferris Bueller's Day Off. And if you haven't seen it, it's about this guy who's in the car park. He takes this really flashy car for a spin. So, and as was in the lecture notes and was in the video, Anthony's video, this guy working at the hotel takes my car for a spin, and he smashes it up on the way. Who's liable then?
He is, or the hotel.
Yeah, well, a good point. Both are, but who's my contract with?
The hotel.
Hotel. So therefore, I can't have a go at him because there's no contract. And that's the concept of privity. There's no consideration, right? Further in your law course, you'll find out that's precise one of the reasons why we have the doctrine of negligent duty of care, because there is no direct link. But it's unfair to have people injured, not get compensation, so they can get it a different way. Okay? And there's a very famous case called Donahue and Stevenson. Have you done that yet? Donahue and Stevenson, the snail in the bottle case?
No. Not yet.
I'll just give it to you because it's pertinent here. I'll use 2018 language. This is in the 1930s, okay, but 2018 language. A guy says to his girlfriend, "Hey, baby, you want to go for a walk?" And she says, "Yes." After a while, he says, "Would you like to have a drink or something to eat?" She says, "Yes." "What would you like?" "I'll have a Coke, thanks." And he buys it for her. And there was an opaque bottle like this. You can't see into it. Okay? Opaque bottle. And she tips the contents out, drinks. And at the end, she tips it out, and all these decomposed snails came out. Okay. Now, she was very ill for quite some time, and she recovered, and she wanted compensation. And no one would give her compensation because there was no contract. Who bought the drink?
The boyfriend.
The boyfriend did. And did she buy a drink? So there's no contract with anyone. Okay. And that was the whole, it was really the beginning of the modern law of negligence. And that will leave for another subject. But why I raise this is actually an important point, because in commerce, where I work, in industry, where I do a lot of work, I will buy a machine and I will give it to one of my employees. So Mary, Michael, Jason, etc. You're an employee, and you use that machine, and that machine is faulty. Okay. Now, you can't sue for breach of contract because you, as the employee, do not have a contract with the party which has sold the machine. You only have a contract through an employment contract with me as your employer. Okay. So therefore, to have other rights, you would go through a non-contractual way, and in due course you'll do lots of study in the area of negligence. Okay, and because negligence and contract basically go hand in hand in the financial world. Okay, so I wanted to go through those to give you a bit of background as this. So we've done Curtis and Chemical Cleaning Company. Can someone tell me about the Four Corners Rule? What is the Four Corners Rule?
It applies to the whole contract. So,
yeah.
So the four corners pertaining to all the content within the contract.
Yeah. And we were given three cases: Gerbold, which they didn't say much on, Sydney City Council and West, and TNT and May and Baker. But I think the example I just gave you with my car is actually quite an appropriate example, because I've given authority to this man to move my car for the purpose of putting it in the storage place somewhere nearby. I did not give him the authority to go for a joyride, etc. Because he took it for a joyride and smashed it up, it goes beyond the what? The four corners of the contract. Okay, and that is also repeated in TNT and May and Baker and Sydney City Council and West. Can someone tell me what happened in Sydney City Council and West? Okay, so Sydney City Council it was a car park operated by the Sydney City Council. A man called West, like you or I, just goes in, leaves the car there, gets a docket, goes out, does his business, and comes back. What happened to the car? Stolen. Okay. And he said, "Well, what the hell's going on here?" And in very friendly manner, Sydney City Council said, "Get lost. There's an exclusion clause on the back. We are not responsible for anything, blah, blah, blah." So he sued. What happened then?
He won because they went outside the contract.
Yeah.
They gave some without following their own rules.
Yeah. Look, I can imagine what happened. It's been a long time since I read the whole case, but I can just, I'm surmising now. I'm a con man, and I go into the Sydney City Council car park. I spot an average car, not too expensive, not too cheap, something I want to make a bit of money out of. I look at it, I get a good feel of the car, and then I make this big sob story up, and I go and see the attendant. I make it look really real, and how I had this awful day, and my parents are dying, blah, 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 blah. And the attendant falls for the sob story and says, look, okay, look, I know you haven't got it. And he shows some bodgy ID and takes the car, takes it away, and it's stripped down and makes a lot of money out of that. And that's probably how in reality it worked. Now the real owner, Mr. West, comes back and says, where's my car? And Sydney City Council have really done the wrong thing. Okay, so it's a procedural thing that they haven't followed, that they need to follow some procedure. And they probably would have installed that after this case. And sensibly, the court saw that it went beyond the four corners of the contract. Okay. Can someone tell me about TNT and Main Baker?
That's the one where he took the truck home for the night.
Yeah.
So he's deviated from his contract, which is similar to Four Corners because he's gone outside his contract.
Yeah, and as Anthony said in his papers in his lecture, it could be seen to be a specific aspect of it, or why not just treat it like the Four Corners? Yes. Because if I had a company and I had lots of valuable goods, I don't want them sitting in someone's truck in a suburban street. I'd want that to be done at a time to be taken properly into the yard or somewhere safe. You're breaching your contract because my goods are not safe. Now, what happened is that TNT would have been the couriers, and they would have said, well, hang on, there's an exclusion clause here. You know? And again, it goes beyond the four corners, okay, of the contract. Okay. Now, tell us about, I think you've told us already about it, the Australian consumer law. Now, we've got two parts to it. We've got the consumer part, which is section 64, and the commercial contract part, which is section 64, capital A. So tell us about the consumer part first. What's the law? And you've given it before. I'm just sort of reiterating. What's the law in relation to consumer contracts and exclusion clauses? Are they effective?
They'll have no effect.
No effect. They've been excluded. And this, what would be the policy reasons for that?
For protection of consumers.
Exactly. Using different words of vulnerable people in the no? And now we will later on you will be doing misleading deceptive conduct. Now, misleading deceptive conduct is one of those provisions in the Australian consumer law. It's actually section 18, which cannot be you can't override it. You know, it'll be effective at all times. And it reminds me, I was dealing with this oil company a number of years ago. I was talking to the chief corporate counsel, and he said, "Oh, I had this huge problem with this machinery which didn't work from overseas, and they refused to honour the warranties. It wasn't very good at all." And he went over and picked the contract up, and he started smiling very broadly. And I said, "What happened?" He said, Australian jurisdiction. The contract's Australian jurisdiction, and you can't exclude Section 18. Okay? And so it's one of the benefits of having Australian jurisdiction. You can't exclude that misleading, deceptive conduct, because they made a whole lot of representations beforehand. And then under the second part, under Section 64A, can you tell me about what the effect of 64A is?
It's where exclusion clauses can apply.
Yeah, in what circumstances do you think they would apply?
I guess you're dealing with, can't remember, I've got to read it. If it was fair and reasonable, the court may pay, yeah.
Yeah, just remember, we have the law floating around us. That's called the default law, okay? And that's the common law. It floats around us. Now, where the government thinks the common law is not doing its job, it will amend it by legislation. So you'll have the common law here, and you'll have legislation which sits on top of it, which will amend it. And over a period of time, it's getting more and more amended. When in the 1800s, it was very, very, very substantially common law. You only had a couple of acts of parliament, one of which would be in the 1600s, which would be the Statute of Frauds, which basically said that transactions in relation to real estate must be in writing. Very, very important things to stop vulnerable people being abused. And over time, we get more and more stuff. And in a couple of weeks' time, we'll be looking at the small business unfair contract terms legislation, because there's been a lot of public outcry about Coles and Woolworths and organisations like that abusing smaller vendors. And so the government has brought some legislation on the 12th of November 2016. And we'll have a look at that, So what I'm leading up to is you can go into transactions, but when there is when there is potentially they're abusive, and there are guidelines in Section 64A, they may be of benefit. Okay. Now, can someone tell me what the contra proferentum rule means? We don't use much Latin nowadays. When I started off, there was a lot of it. Now, thankfully, it's a lot of it's gone.
Benefit of the weaker party. Is that it?
What does the word contra mean? I hear a contrary opinion.
Yes.
Opposite, so against. And proferentum is to prefer. In other words, to offer to someone. So it goes against the person who's offering it. So what happens is that if there is look, I write a contract, I put an exclusion clause in it, and it's not clear. What that means is that the interpretation of that clause will be against me because I've written it. If I meant to say this in the first place, why did I not say it? What we want to have is people who don't suffer due to poor drafting. I shouldn't rely on my poor drafting. So the rule says, if I draft a clause and it's absolutely crystal clear, we know the golden rule is, if clause is clear, that's it. It's a signature there. Or indeed there's no signature. However, if there's an ambiguity, the ambiguity will be read against the person that drafted it. Everyone see that? So it'll be used against you. Now, as a matter of interest, we're going to be doing a couple of key clauses later on. Entire contract, termination, force majeure. Another clause we could have done is the clause which goes contrary to the contra proferentum rule, which basically says, I know I wrote the contract, but we both agree that if there's any ambiguity, the interpretation will not be against me. I can actually write that. And large organizations put it in. I just had one yesterday on that. Okay, so the case there is Wallace and Pratt and Haynes. So anything on exclusion terms? You want to talk about anything there?
No, it's pretty good.
Okay, so that's the second of the third. The first one was basically the clarity. The second one is exclusion terms. Exclusion terms are really, really important because in commerce, everyone's scared that they're going to get sued and for how much, and they're going to exclude. Or another word, there are three things. There are indemnities, there are exclusions, and there are caps. Exclusion is, I'm not responsible for anything. A cap is, okay, if I'm responsible, I'm only going to pay up to this much. And indemnity is, you make a mistake, you pay me. And they're three very important concepts which you'll, in due course, pick up. Irrespective of whether you stay in the law, in other words, become a solicitor or a barrister, or whether you use your law degree to go into commerce or business, Naturally, of course, the things I've just spoken to you about aren't in other areas like, say, family law or refugee law and stuff like that. But if you stay in commerce, that's that's where they'll be. All right, so we've done that now. Let's go now to a couple of key clauses. Can someone tell me what the purpose of an entire agreement, it's also called entire contract clause, is? What's the purpose of that?
It's to get away from all the other evidence pre-contract, so emails or verbal or anything. So the contract's the contract, and everything from there is beyond that.
Yeah. So let me use different words. Is that Michael, you and I are on a contract. You don't want me to come back later on and say, oh, but you said Joe or Frank or Bob said we could do this. That really causes lots of problems. So what we do is very clear, this is the contract, all the terms and conditions are in the contract. What's not in the contract is not in that document, is not in the contract, no verbal. So it's an important document, and we've got that case of Hope and RCA. Now, termination. Someone tell me about termination. We did termination last week. There was a thing about distinction between conditions and warranties and intermediate. Can I have a can too, please? Tell me the difference between a condition and a warranty, first of all.
Conditions, what the contract's based on. Without it, the contract can be not entered into. It could be invalid. Whereas a warranty is maybe damages at most. Yeah.
What we tend, if you look at different textbooks, they tend to shy away from the words conditions and warranties. It's not to say you have to, only because condition has a number of meanings to it, as does warranty. And so what we tend to use essential and non-essential terms. And Kumpar 2 is the High Court case for about 10 years ago, maybe a bit longer. But nonetheless, it's all the same. A condition goes to the heart and soul of the contract. And if there's a breach of that, you are substantially deprived of the benefit of the contract. I mean, why would you want to continue if you've lost the benefit of the contract? I may have given you the example of the car last week. I fly into the Gold Coast to do some work. I hire a car. And two things go wrong. The first one, the CD doesn't work, and it's only there for music, pleasure. And the second one, the motor doesn't work. Clearly, the motor not working is a breach of a major term, also called condition, also called essential term. It goes to the heart and soul, and I'm completely deprived of the benefit of that contract. And therefore, it doesn't, you don't have to be Einstein to realise that the remedy there would be either walking away from the contract, termination that is, or damages, monetary damages. But if it's a minor clause, in other words, also known as a non-essential or a warranty, well, you can only get damages if there's any. Okay, and remedies will be discussed in contracts B at a later stage. Okay, so that's conditions and warranties. Now, that's from last week. We haven't discussed it yet. What you can do in a contract is you can change that if you wish. See, what I've just discussed with you is the default law which floats around. So if nothing is said, there's an oral contract or a written contract. Here is my car. It is a 2012 Commodore. It's done 100,000 kilometres. In fact, it's done 400,000 kilometres. So I suggest to you that's potentially it's a breach of a condition. Okay, but if you in a commercial contract you want to change part of that, and you want to say that things which are ordinarily warranties, you want to make them conditional, make to be treated as conditions. Well, therefore, you can do that. Anyway, so under the heading of termination, there were two subparts. The first one is rights, which we've just discussed. So a termination clause will talk to you about the rights that you're entitled to, but it may also discuss the procedure. Okay, so the rights one were not only do you have the common law rights, but we're going to amend them that things which are ordinarily warranties will now be treated as conditions. That's under the heading of rights. And it also, the second one I want to talk about now is procedure. This is the procedure we have to use. So could someone give me the case of Commonwealth and Aman's case? A-M-A-N-N, Aman's case. Can someone give me that?
It was about a contract with the airline to with the Commonwealth government, but the war came in and they were unable to fulfill the contract to provide this chlorine stuff to Germany because it was prohibited.
Okay. That's another case, that one. A little bit further down. Aman's case is an Australian one. There are two really embarrassing cases for the Commonwealth, and this is one of them. The other one is Hughes Aircraft Corporation, but this one here is one of the two most embarrassing cases for the Commonwealth. The Commonwealth was worried about the Vietnamese boat people overfishing. I don't think we had terrorist issues at the time, and it had planes flying around the coastline, just keeping an eye on things. The Army, Navy, and Air Force was doing their job, but they also wanted to get private contractors to do it. And they had a contract ending, and they had a new guy starting. And this man was called Aman, and he promised the earth but didn't deliver. And there came a stage they got so exasperated with him, they went to the contracts. Well, I don't even know where they went to the contract. They just booted him out. Does everyone remember that case?
Yeah, we read it today.
Yeah. So what happened then? They booted him out.
They didn't follow. Didn't follow his rights and procedures to actually kick him out.
Yeah. Now, I can't tell you how many seminars I've been to as a recipient, just sitting there, and the speaker says, look, if the clause says you have to do 1, 2, 3, 4, he just said, just do it. You know, even if you have to even send a letter to the original registered office of the business, because that's what the contract says, just do it. Take a photograph of someone putting in the letterbox, or a video of it, but just do it. You don't want a situation where they come back later on and say you didn't follow the contract, because the job of the judge is to enforce the contract. And the first part of the contract is, if you want to terminate, you have to use the procedures set down, agreed between the parties. And if you don't do that, it's a breach of contract. Okay, and as you see here, so who won the case? Aman won the case, and you got substantial damages. He's probably laughing all the way to the bank on this. So the moral of the story is, it's pretty straightforward. If the contract says X, Y, and Z, you do it. And what I've seen a lot is, you get these CEOs who want to get action. They want action. Look, we know the guy, or not necessarily Aman's case, but someone's breached. Look, we know he's breached. Just get rid of him. Well, we should follow the contract. No, just get rid of him. Get rid of him. We too much time wasted. No, you've got to follow the contract. That's it. So that's termination. The next one is force majeure. Tell me about force majeure. What does that mean?
A natural disaster or acts of war.
Good. And if it's good. Thank you, Jason. What about if we translate in English? From which language does force majeure come from? French. Okay. What does force mean? Force. What does majeure mean? Major force. Okay. It's a major force you've got no control over, which has affected your way of doing business. Now, buyers absolutely hate force majeure clauses, because I don't want someone who's providing me with goods, let's say in IT services, basically not providing me, making some excuse of, oh, look, electricity didn't work. Well, I want you to have a backup service. And vendors are petrified if they don't have one, because they have to give 100% service. So there is this tango between the two parties, and generally speaking, a force majeure clause will end up in the contract, but the force majeure will depend on the parties. Look, if there is no force majeure clause in the no force majeure clause in the contract, you have to do what you're supposed to do. I wrote an article on that. Did I send it to you guys? An article on it? But anyway, it's probably beyond the scope of this course. But force majeure is something agreed between the parties. If they can't agree and the contract has nothing about it, well, therefore, the vendor has to do as they promised. If there is a force majeure, that means that the vendor is excused, but only according to what's been agreed between the parties. An example may be I was supposed to deliver something, but there's been a major storm, or the planes aren't going. I'll give you an example. I'll just make this one up, okay? So I live in Melbourne, and I've agreed upon an organisation to deliver a course in KL, okay? So the day before, I hop on the plane, and as we get close to Indonesia, it turns around because there's a volcano. And volcanic dust and airplane engines don't mix. Okay, so theoretically, the promoter in Kuala Lumpur could lose a lot of money because they have to repay all the money. And then what are they going to do? They're going to have a go at me because I breached my contract. I said I would be there the day before, and I was going to do the presentation. You see it? So that's why it's important from a risk management viewpoint to put these clauses in. Indeed, I just have one of those in my contracts, and I say that, for example, if I can't due to an event beyond my control, including transport, blah blah blah, and own illness and family illness of a direct family member, serious illness, there will be the force majeure, and everything will be put on hold. So force majeure is actually quite an important one. And Mary, I think that case that Wilson and Tennant that you were talking about before. Wilson and Tennant. Yes. So what happened there is that there was one organisation was selling chemicals to another organisation at a certain price. World War I started, and they couldn't get their supply from Germany. Now they had a contract with the customer, and they had to meet that. Let's make it up: $100 per ton. Suddenly goes up to $1,000 per ton because they have to buy it from somewhere else and have it shipped. And they wouldn't supply it anymore. And the buyer says, well, hang on, we've done nothing wrong. We want our supply. And the vendor makes all this excuse up about force majeure. What did the court say? Did the court treat it as a force majeure event?
No.
No, exactly. They said that nothing stops you from getting it elsewhere. And just because it's going to cost you more, well, too bad. Okay? A force majeure event is a genuine event which stops you from doing it. And in the example of the plane going from Melbourne to KL, but have to turn around due to an event which I had no control over, is an example. And so therefore, when you're going into contracts with your clients, or you're working for an organisation in a managerial capacity with a law degree, and they ask you to consider these things, think of the risks involved, and think of you should be putting one in. And if you're the buyer and a vendor puts one in, think about the opposite. How wide is it? I would not accept a clause which had all these events, including means wide. I want it the other way around. I'd be very, very careful. If I was a buyer, I'd make sure, yes, the vendor need to give them a bit of a break, but we don't want to give them too much. And if I was the vendor, I'd make it as wide as possible. And that's why law schools are brimming over at the moment, because lawyers are very much required in relation to commercial contracts. Not to say in other areas as well, but mainly our area is commercial contracts. Okay. So we spoke about the force majeure, and that's really all I was going to talk to you about in relation to the background here. Any questions on that?
No.
Okay, so let's go to the problem. We've got young Michael and young Libby, friends. Can someone tell me the facts of it? Just paraphrase the facts.
Well, it's about a house swap. He's going overseas and he decides to put some conditions on a written contract.
Yeah.
And what we don't know is whether that was a signed contract, and certain events happen which contravene or breach that contract to a degree, and ultimately his house is destroyed and he wants some compensation. But the woman that did the house swap pulled out of the contract, but we don't really know whether she sent an email as was in that exclusion clause, and within 48 hours notice. It doesn't really tell us that. So,
well, Mary, I got to say that's good. I like the way you've done that. You've picked at some of the key issues here. Michael and Libby trust one another, but to be on the safe side, they concluded a written agreement. So we don't know whether it's signed. You might say, I assume it's been signed because of the word concluded. And you can make certain assumptions. And also the examiner has put the assumption here. It said you may assume basically all the elements of formation are properly met. So we've got to talk about the stuff basically which relates to today's materials. And then some of the other issues you picked out there. So that was good. Now, let's look at the first question. The first question is whether Libby needs to replace the plant that died from overwatering. Who'd like to have a go at that?
well, there's two sides to it in a way, because he gave explicit instructions, and we don't know whether that was before contract formation or not,
Good.
that plants were to be watered every day. And in doing that, there was a plant that only needed to be watered once a week, and that died as a consequence of overwatering. So, like, I'm not really sure which way to go with that.
Just before you go, have a look at the facts. The contract included a clause in which Libby agreed to water the plants every day,
Yeah.
and to be liable for any plants which died while she was house sitting. So from that, I'd assume that they had a discussion and that she agreed to water them daily, and that she agreed that any plants which died during her house sitting, that she would replace them. Okay, so where would you go from there?
Well, on the face of it, it would seem that she is liable because the plant died while she was there, but realistically it died because of overwatering. So that's where I'm not sure.
I'd say she's not liable.
Yeah, I agree with Michael.
And that's the Gibbord versus Great Eastern Railway Company. She's doing what she was told to do, and circumstances come from that fail, then so be it.
So which case was it, sorry?
Where did I have it? Gibbord versus Great Eastern Railway Company, 1921.
Under the Four Corners rule. Let's go and have a look at that. And when we go to our notes on page 12, if you undertake to do a thing in a certain way, or to keep a thing in a certain place with certain conditions protecting it, and have broken the contract by not doing the thing contracted for in the way contracted for, or not keeping the article in the place in which you have contracted to keep it, you cannot rely on the conditions which were only intended to protect you if you carried out the contract in the way in which you contracted to do it. So this is all about the Four Corners rule, isn't it? Yeah. So let's go back to, again, the hotel which accepts your car. You agree to do it in a certain way. And if you do it in another way, causing loss, well, you're not protected by an exclusion clause. Okay. So there is no exclusion clause here, is there?
No, I thought this was just
Four
as
corners
simple
rule.
as I thought this was just as simple as reading the legislation. I didn't think it made an absurdity in any way.
Look, I haven't spoken to Anthony about this, but my gut feel, I might be wrong on this, my gut feel is it's the golden rule. It's clear, and even though it turns out with a seemingly unjust result, I think she's bound with us. Because I started thinking about, there might be two interpretations to it, but I reckon it's relatively clear. That's my feel on that. Any comments on that?
Well, that was like, that ABC versus APRA or whatever it was. That was the that was the principal brace in there. It became an absurd outcome that because the contract was so clearly stated, they had to follow it. Yeah.
If we go back to ABC, just bear with me. I'll just go back to that part there. ABC and APRA. They said here, if the language is open to two constructions, that will be preferred, which will avoid consequences which appear to be capricious, unreasonable, inconvenient, or unjust, even though the construction adopted is not the most obvious, the most grammatically accurate. But that all presupposes that you had two constructions.
Yes, but in that case, they didn't.
In which case?
That ABC one. If you read,
And I was thinking with this case, what we're doing now, this problem 12. I originally thought to myself it's an ABC and APRA case because there are two different interpretations. And then I thought to myself, there's a good argument that we use the golden rule. It's clear and concise, okay, maybe the parties should have at the time been a bit more careful. Okay, so I really can't speak more about that one. The next question to whether she has breached the contract in relation to the wheelie bin. Would anyone like to have a go at that?
Well, I don't think so because the contract stated she had to clear the mail. What it didn't state, or what we don't know if it stated, is that she had to actually put it in a certain place. I mean, so basically she cleared the mailbox, she just threw it in the bin, which is, an immoral thing to do, but she followed the contract of clearing the mailbox every day.
It's illegal to dispose of other people's mail into a rubbish bin, so you're breaking a legislation.
Okay. Maybe some of the people weren't aware of that. Maybe she could have put it, in some place he couldn't find it for 5 years or something like that. But Jason, you there? You want to have a go at this?
Well, I was with Mary there. I just applied the golden rule to that as well because the contract didn't specify where it had to go. It just had to be removed from the mailbox.
I had to think about this, and I went to the BNP Paribas and Codelpha case, looking at surrounding circumstances in case of ambiguity. What would a reasonable person think of the circumstances encountered by the parties when they made their contract? What do you think a reasonable person would have said?
That you put it in the house.
Yeah, or somewhere which can be located without you, make it easier to find.
See, I get a little confused here. So, from reading this week's study guide, if the words are so clear, where's the absurdity been raised in that question, in that clause there? So all it says is that you're taking the mail out of the mailbox. You're clearing it daily.
Okay, good point. Good point.
So I get. Yeah, of course, a reasonable person would assume that you'd take that inside and put it on the kitchen bench or whatever. But that's I don't know. Sort of what from my reading this week, I understood that if it was clear enough, that was all you needed to concern yourself with.
She has breached the contract as well, but she has broken legislation, so it's criminal.
No. So what Jason was saying is in a way it's not dissimilar to the first question.
Yeah.
Yeah. Look, I tell you what I might do is I'll have a think about that during the week, and when we meet again next week, go through it, because that's a good point there. You see, in practice, you never can tell with a great degree of certainty which way it's going to go. And you've probably heard it many times. Look, I have no idea how the judge is going to think on that day. And what they usually say in a humorous way, say, well, it all depends on which side of the bed the judge got out in the morning. So some of these things get pretty close. Now, the third one was whether Libby's termination of the contract is effective. What do you think?
Well, it doesn't really state whether she emailed within 48 hours. So I was
4 hours.
About that as well.
But the fact is that she sent it. You send it. It takes 24 hours to come into effect. But the house is no longer habitable. So already the contract's over because the house is ruined and not livable.
Well, I went a step back from that, and I went with saying that termination clause. Hang on, I'm just reading here. Libby is committed to Michael's promise to care for his house while he is away, and in return for that promise is offered accommodation and general use of household items. By putting a termination clause in for no particular circumstance, it makes both parties' promises illusory. Does that seem questionable?
Under what circumstances would you perhaps terminate a lease like that?
Well, it didn't actually specify. So if she just terminates for no reason, they're not really holding up either side of their promises, are they?
More of a contract to what to do while you're there than...
Yeah.
This is right.
Well, what consideration was to start the contract off? There would have been some consideration, wouldn't there? She's paying. Is she paying? No, she's doing work and he's providing the premises.
Yeah.
And then at a potential later date, the parties can terminate at 24 hours notice. But see, what happens is that why I think it's not illusory is because you have a duration of something which may happen in the future. So therefore, Jason, for example, I'm running a mining company, and you're a contractor, and I have a clause that it's a 3-year contract. But if the economy gets worse, I can what did it say here? Under a clause which either party could terminate within 24 hours by email, but within 24 hours notice.
Yeah.
Because there is, we have been doing some work. Now, so we were talking about whether she could terminate. See, ultimately, what is the contract about? She provides services in return for the use of the house. Okay. Now, if there's a major breach, which is a condition, if she provides no more services, he could terminate with 24 hours notice. And what about if he takes the property away from her, or it burns down, or whatever? She doesn't have access to the property anymore. Okay? And it makes sense for her to terminate because therefore her obligations are no longer necessary. She doesn't have to hang around and do all these things. So my gut feel is it was a breach of a major term in entitling her to do that. And you, as one of you said before, you've got to follow the procedures set out in the contract, and that was an Aman's case. Remember how they said with Aman's case, we've got to follow the procedure there?
Yeah. Yeah. But wouldn't the fact the house is burned down end the contract? Because you can't fulfill it anymore. The contract's already terminated.
Yeah. Well, there is a thing in law later on which you'll learn that it's called frustration of a contract, where the subject matter has been lost. But because we haven't studied that, we're not considering it here. But certainly, it's certainly the case. But there is a breach there that she doesn't have access to the premises anymore.
But then, of course, there's the fact that she deliberately, like, although he said in the contract he was responsible for electrical faults, she deliberately caused that to happen by having this ladies' night and overloading the circuit. So,
she hasn't deliberately overworked the circuit.
Yeah.
You can't. Nothing there said you can't have a party and you can't play music and you can't do this.
Well, no. Well, you wouldn't a reasonable person assume that house sitting would consider, doing your general house chores like getting the mail, taking out the rubbish, and things like that. I don't think a reasonable person would think that house sitting permits you to do a party as well.
I don't say mean about the party, but she hasn't deliberately burned the house down. I mean, she couldn't have stated that there was going to be an electrical fault.
But it really was retributive behaviour because he demanded for payment for the plant, which he felt was unfair. That started her throwing his mail in the bin and then deliberately holding it.
Now you're looking at it subjectively now.
Yeah, that's the thing. That's different. That doesn't mean she's burned the house down. Yes, she's acting like a little girl, but she hasn't burnt the house down deliberately.
And you could argue, look, just having an entertainer come around, you pick the phone up and you say, entertainer, please come over for 1 hour, $100, that's fine. And they didn't know he was going to bring all this equipment, and he plugged it in, and caused the fire to occur. But nonetheless, there is a major breach there. She no longer has a house, okay? And she's substantially deprived of the value of that contract. Okay, so going on to the fourth and final one, whether she can rely on the exclusion clause. So the exclusion clause was a clause in which Michael agreed that Libby would not be liable for any damage caused to the house as a result of electrical faults.
Well, yes.
Now, the question was, can she rely on the exclusion clause? Okay, what do you think? And so, Mary, you think yes?
Well, yes, after what you just said, in terms of the fact that she couldn't know that having that party would end up overloading the system and causing a fire, and he expressly said he would take responsibility for electrical faults. So, on that basis, I would conclude that she can rely on that.
Not reliable caused any damage. A clause in which, I'm just reading the clause out, a clause in which Michael agreed that Libby would not be liable for any damage caused to the house as a result of electrical faults.
Yep.
Okay. Is there any ambiguity in that?
No.
I think that's the first question you could ask.
Yeah.
Any ambiguity? Let's not answer that for a second. If there was ambiguity, which rule would you use? Contra proferentum. Contra proferentum means that you interpret against the party which is trying to rely on it. In other words, you'd give Michael the benefit of the doubt. Okay, so it all depends. And it can go either way. It depends on the facts. You see how now how difficult it is to predict a court case. If you had $1 million case just on this matter, and we're going to trial tomorrow, it's really hard to bet on it. You couldn't say certainty. You could say, "Oh, look, I think it would go this way, could go that way," and you try to work out the arguments from both sides, and then to weigh them up and see who's more likely. And in a way, that's not dissimilar to an examination question on either a written examination conditions or an assignment. You can't really tell. You've got to go through the facts there. For each side, because when you read the judgments, and some of these judgments get very long, the judge that just does that. They go through all the different facts, as you have here. You go through the facts on both sides, and then look at which weighs more and which is more has more effect. So who thinks that she can rely on the exclusion clause?
Yeah.
So, Jason, you reckon will?
That was Michael, but I also think that it's pretty straightforward when you read it.
Would not reveal.
That's default.
So she can, on a plain reading of it, a clause in which Michael agreed that Lily would not be liable for any damage caused to the house as a result of electrical faults. Plain reading. Remember the exclusions to exemption clauses, the four corners. Notice was given there, misrepresentation. Some of these deal with unsigned documents, but the four corners. The only one.
The answer I actually argued was with the four corners rule and said that, you know, it was outside of the contract that, due to the examples that were given in that four corners rule, it was outside of the contract for her to have a power party. Because like that example with the mechanic borrowing the car to go for lunch and damaging the car.
She's living there and allowed to continue on with her life and find someone that doesn't have friends over when they're house sitting. You know, like, yeah, and stipulated that she couldn't have anyone over as well. So, you know,
I think there's a you could mount a reasonable argument to say she hasn't gone over the top. I can't remember the facts. Half a dozen friends or so, wasn't it?
12, I thought it was a dozen.
Oh, sorry. Here we are, a dozen friends. Now that gets a little bit.
Sounds to me like she was partying pretty hard.
I had a New Year's party with, say, 30 people here at my house, and that wouldn't have shorted my electrical wiring.
Look, coming from an electrical perspective, I can tell you now a smoke machine and a few other things would probably not cause too much damage.
Exactly. So
that's my professional opinion, but
you know what you do is you would give the rule first, and you'd say that look, she would there is an exclusion clause there. She would she'll be able to use it, and unless one of these exclusions came into it, and you look them up and weigh them up, and then you make a conclusion from there. And that's how it would work in the real world.
So with exclusion clauses, even if legislation reads clearly, can you still apply those other rules, like the four corner rule and stuff like that?
Yeah, because that's what it's there for the exclusion clause, because the four. See, remember in Sydney City Council and West and TNT and May and Baker, there are exclusion clauses.
Yeah, but what I get a little confused with is when you read that first paragraph of the reading, it says the golden rule applies first before you go on to apply anything else. Not exactly like that, but along those lines. That's how I read it. I could be wrong.
Yeah, but what happens? The policy, the governmental policy, is that yes, it will allow exclusion clauses, but they are ripe for abuse, and so there are safeguards. The whole history of contract law is littered with judges trying to bring exceptions in to protect vulnerable people, and also legislation, whether it's Queensland, other states, and or the Commonwealth. An example of the Commonwealth is the Australian Consumer Law. Okay, and that's to vulnerable people. Look, I'd be tempted to say that, look, it depends on the facts and how you look at it. See, some of you are laughing and saying, 12 people is a mega party. Other ones could say, it was just a few friends around having a peaceful. See, you could, this is interesting. You could have, like I think Michael said, 30 people and have a nice, relaxing time. Everyone's just taking it easy. Or you can have 3 people breaking the windows and really whooping it up. Okay. So what I'm trying to say is that the number of people, yes, it is a factor, but it's not a conclusive factor. You need to look at other factors, and then you weigh the whole lot up. What else have we got? We've got, okay, they had this entertainer come, all right? So entertainment came, did a bit of a song and dance trick, brought their own music in. that may show there was a bit of whooping going on, and the fact is that there was a dozen of them. It tends to go to the side of there being a party there, and a pretty big party. But were they? Should they be responsible for burning the place down? What has she done? She's got this guy. In fact, he should be having a go at. Michael should be having a go at the entertainer who brought the stuff along.
Well, he can't because he doesn't have a contract with that person.
Okay, and as we had this earlier discussion, there'll be a situation of potential negligence there. Right?
Yeah.
He's not an electrician, so he wouldn't know that the house wiring's faulty. And anyway, that comes back on Michael for having a poorly wired house. But doesn't that come under force majeure as well? Because I know it says floods, cyclones, and bushfires, but also they may result in human conduct such as warfare and strikes. So that's like an act of God, the house burning down through electrical failure.
Well, it's electrician's negligence.
Not really, because it's overloaded it's overloaded the power for the place. So it's not really an act of God. It's a man-made act that's.
Yeah, but you can't continue. Well, so are wars and strikes. They're man-made.
Yeah.
So let's have a look at force majeure again. They used to call it act of God. And if you're interested in this, there's a film called The Man Who Sued God. It's about 20 years old. Billy Connolly, filmed on the north coast of New South Wales. And his yacht gets burnt down and by a lightning strike, and the insurance companies tell him to nick off because they say it's an act of God. So, all right, so he sues God. It's actually very clever, you know. But if you look at the list of things that you can have in a force majeure clause, there would be strikes. That's not an act of God. It could be, yes, indeed, you could have earthquakes, you can have volcanoes, but nothing you got no control over. Let's say, you've got Elvis coming out and he dies in the meantime. Well, that's not an act of God. I mean, maybe the death is, but I'm just saying that the human being wasn't an act of God. So an act of God is just one part of the list of items that you can have in a force majeure clause.
Yeah.
So look, what I'll do is I'll have a chat to Anthony during the week and quickly go through this with you at the beginning of next time. But the core thing is that you understand the law and you can apply it. What I always do is I do flow charts. It's easier for my mind. I can see it because there's a lot in here. We've only had, from memory, 11 cases here. Quite some weeks ago, we had about 28 one week. You know, you just got to know your cases. But remember, the flow chart. We don't make the flow chart. The cases make the flow chart. Every case which comes in makes a new category. Sorry, not every case, but a special case will come in and make a new category, and it'll make a different branch. And what we do when we do a flow chart is the different branches of cases. And then it's tempered by legislation, because the purpose of the legislation is very simple, is to assist in areas of vulnerability. I mean, that's just one reason for it, but there's a lot of it there. But still, contract law and negligence law, or also called tort law, are the two areas where you've still got lots and lots of case law, substantially case law based. Very substantially, with a little bit of legislation coming. So you need to know that. You need to know all too. Now, later on, you'll be learning about. I'll just finish off with this. You'll learn about equity. Now, contract law. When you get a remedy, the remedy may not suit you. The remedy is only damages. If you want more than a remedy of damages, you'll need to go to the law of equity, which is good conscience. If someone's done something to you and the remedy is so small, someone's stolen something from you, you want it back, and the damages are very small, you go to the law of equity. So what I'm trying to say is that later on you need to know the law of contract, the law of equity, which is above that, and the law of legislation on top of that. So you can see why the general public have so much difficulty with all this, right? Because there's three layers of law. And then legislation is state and territory on one side, and then Commonwealth on the other side. If you really want to be technical, you've got local government as well, but they're usually not so important for most of us. You know? All right. So what I do propose to finish off now, and we will continue next week. We'll be talking about implied terms. An implied term. Does anyone know what an implied term is?
It's not expressed, so it's just
lovely. Exactly, it's not expressed. An expressed term is one which we clearly state. I say to you, Michael, I offer to clean the barnacles off the bottom of your boat for $50 plus GST. And he says yes or no. If he says yes, this is a contract, and that's the terms. But an implied term would be, I would do it with proper skill and care. Okay?
Yeah.
And that's never so stated, but it's just as important, just as much a part of the contract as we've been. All right. Nice to see you all, and keep on trucking. And I've done lots and lots of the assignments, and I still need a bit of time to finish off. It's hard work. Okay.
Yeah. Just one question.
Please.
Force majeure, you'd say it's not a disaster as such because it's electrical, or I just don't know what you're like. You think it's not barking up the wrong tree, or 50-50? We've all disagreed on this one, so it's kind of good. You know, it just shows, law.
So force majeure is about an event which comes in, a supervening event, which you've got no control over. I'd suggest that she had control because she invited the man into the property. Okay. Now, you could easily argue, yes, she invited the man into the property, but she didn't know he was going to bring all this electrical stuff.
Yeah.
Okay. So force majeure would mean there's an event which has occurred which will put a stop to the contract, but force majeure, how would that affect here? It's usually it's gone beyond force majeure. It's really frustration. Frustration is the legal doctrine where the subject matter has been destroyed. And the most famous case there, just on the tip of my tongue, it's there was a rock and roll concert to happen on Saturday, and on Friday the hall burned down. And basically the subject matter is gone. How can you run a concert?
Yeah.
Is that not similar to this one here? How can you run a contract here where the purpose in this case was to live in the house, and in the other one they use the hall for a rock and roll concert? Leave it to me. What we'll do is I'll have a chat to Anthony, and I'll run through it again with you next week. Okay.
All right. Thank you for that.
Oh, all the best to you. Catch you. Bye-bye.
That's it.